All right, so you own property with someone else, but you can't agree on what to do with it.
Yeah, you're in a bit of a predicament.
It can get messy, especially with inherited properties.
Yeah, it definitely can.
Like, what if you inherit a beach house with your siblings, but can't agree on whether to sell it rented or just keep it for family vacations?
That sounds like a recipe for disaster.
Luckily, today we're doing a deep dive into partition actions in California.
That's right.
We've got legal guides, case studies, even advice from attorneys at the Martinez Law Center in Santa Ana.
They specialize in these types of cases.
Exactly. So we're going to break it all down for you.
Should be pretty interesting.
So let's start with the basics. What exactly is a partition action?
Well, in simple terms, a partition action is a legal process that allows co-owners of a property to divide or sell the property if they can't agree on what to do with it.
Okay, so it's a way to force a resolution when everyone's at a standstill.
Yeah, you could say that.
And this is especially relevant in California, right?
Absolutely. California law actually grants a near absolute right to partition.
Meaning?
Meaning if co-owners can't agree, the courts can step in and make a decision for them.
Wow. So it's not just a suggestion. It's like the law's way of saying, figure it out or we'll do it for you.
Pretty much. Yeah, it's designed to prevent these disputes from dragging on forever.
I can see how that would be necessary. Imagine siblings arguing over that beachfront property for years and years.
Exactly. It can get really messy, and that's a classic scenario where a partition action might come into play.
Speaking of scenarios, we've got some really interesting real-world cases in our sources.
Oh, yeah, fill me in.
We've got that beachfront property dispute between siblings in Orange County.
Right? Sounds familiar.
A case involving a family farm in San Diego.
Multi-generational, I bet.
You bet. And even an investment property disagreement in Riverside.
So a little bit of everything.
Yeah, it seems like anything can trigger these legal battles.
You're telling me.
But these cases also highlight the different types of partition actions, right?
Oh, yeah, for sure.
So what are the main types?
Well, the most common type is partition by sale.
Partition by sale.
Yeah, where the property is sold and the proceeds are divided among the co-owners.
Okay, so that's like the cleanest break. Everyone gets their share and moves on.
Right. In most cases, that's the simplest solution.
But sometimes selling isn't the best option.
Yeah, exactly.
What happens then?
Well, that's where partition in kind comes in.
Partition in kind.
Yep. This involves physically dividing the property among the co-owners.
So you actually split up the land or the house or whatever it is.
That's the idea.
I can see how that would be tricky.
It can be. Yeah, especially if the property isn't easily divisible.
Like if you have a single family home, you can't really chop it in half.
You can't, yeah. So partition in kind is more common with larger pieces of land, like that family farm in San Diego County.
Right. That case is a perfect example. They were able to divide the land and keep it within the family.
Exactly. And that's often a desirable outcome in these cases.
But there's one more type, isn't there?
You got it. Partition by appraisal.
Partition by appraisal.
Yep. In this scenario, one co-owner buys out the other co-owners based on the property's fair market value.
So you get an appraisal, and then someone pays the others their share and becomes the sole owner.
That's how it works.
Interesting. And we see this happening in that Riverside investment property case, right?
Yep, exactly. One of the investors decided to buy out the others and keep the property.
So we've got these three main types: partition by sale, partition in kind, and partition by appraisal.
Those are the big ones, yeah.
And each one has its pros and cons depending on the situation.
For sure.
So let's say you find yourself in this predicament. You're a co-owner and things just aren't working out. What's the first step?
The first step is to talk to an attorney.
Okay, so get some legal advice.
Absolutely. An attorney who specializes in partition actions can help you understand your options, the legal process, and the potential outcomes.
And I imagine they can also help you navigate the emotional side of these disputes, which can be pretty intense.
Oh, yeah, absolutely. These cases often involve families or longtime business partners, so there's a lot more at stake than just the property itself.
Right. You've got relationships, history, all that stuff tangled up in the legal mess.
Exactly. And a good attorney can help you navigate those complexities and hopefully find a solution that minimizes the damage.
So finding the right attorney is crucial.
Couldn't agree more.
And for those of you in Southern California, the Martinez Law Center is a great place to start.
They have a lot of experience in these cases.
Absolutely. They've handled everything from beachfront property disputes to family farm divisions.
They're the real deal.
Now it's not just about filing paperwork and waiting for a judge's decision, right?
Oh, no, there's a lot more to it than that.
What else should people be aware of?
Well, for one thing, accounting plays a big role in partition actions.
Accounting?
Yeah, it's all about figuring out who contributed what to the property.
So who paid for what? Who put in the most money? Who's responsible for any debts?
Exactly. All of that gets factored in when determining how the property is divided or how the proceeds are split.
It makes sense you want to make sure everyone gets their fair share.
Right. And accounting helps ensure that happens.
Now, things have gotten even more interesting lately with recent changes to California law directly affecting partition actions.
Oh, yeah, there have been some significant updates.
And these are particularly relevant for anyone who owns property in California, right?
Absolutely. These changes can have a big impact on the outcome of these cases.
So let's talk about some of these changes. What are some of the highlights?
Well, one major change is AB 976, which focuses on fair market value during buyouts.
Fair market value.
Yeah, it's all about making sure that when one co-owner buys out the others, they're paying a fair price.
Okay, so it's about preventing anyone from getting lowballed.
Pretty much, yeah. It aims to create a more equitable outcome for everyone involved.
Makes sense. What else is new?
Another important update is SB 1146, which provides extra protection for elderly or dependent co-owners.
Okay, so this is about protecting those who might be more vulnerable in these situations.
Exactly. It aims to prevent them from being taken advantage of or pressured into making decisions that aren't in their best interests.
It's good to know the law is looking out for those who need it most.
Definitely. And then there's AB 2175, which streamlines the process for certain types of properties.
Streamlines the process.
Yeah, it aims to make things a bit more efficient for everyone involved, especially when dealing with properties that meet certain criteria.
So it's all about cutting down on the red tape and making the process a little less painful.
That's the idea.
I like it. Efficiency is always a good thing.
For sure.
So we've got these new laws that aim to make the process fairer, more efficient, and more protective of those who might be vulnerable.
Exactly. It's all about improving the system and making sure everyone gets a fair shake.
Sounds like a step in the right direction.
Definitely.
Now, the Martinez Law Center shared some great advice for anyone even thinking about going down this road.
Oh, yeah, they're a wealth of knowledge.
What are some of their top tips?
Well, first and foremost, document everything.
Document everything.
Yep. Keep track of all expenses, communication agreements, anything and everything related to the property.
Okay, so create a paper trail.
Exactly. That documentation can be crucial if a dispute arises. It can help prove your contributions, your expenses, and any agreements you've made with the other co-owners.
Makes sense. What else do they recommend?
They also advise exploring alternatives to court action, like mediation.
Mediation.
Yeah, it's a way to try to resolve the dispute outside of the courtroom with the help of a neutral third party.
So it's about finding a compromise that works for everyone.
Exactly. And sometimes mediation can be a much faster and less expensive option than going to court.
It's worth considering, for sure, especially if you want to try to preserve relationships.
Absolutely. And the Martinez Law Center also stresses the importance of understanding your rights as a co-owner.
Know your rights.
Yep. You need to know what you're entitled to, what you can and cannot do, and what options you have available to you.
Right, because you don't want to go into this blindly.
Definitely. And finally, they emphasize the importance of being prepared for the emotional side of these disputes.
The emotional side.
Yeah, as we talked about before, these cases can be very emotionally charged, and it's important to be prepared for that.
So you're saying don't underestimate the stress, the anxiety, the potential for conflict?
Absolutely. It's real, and it's important to be prepared to deal with it.
So we've got some great advice from the experts.
Yeah.
Document everything, explore alternatives, understand your rights, and be prepared for the emotional roller coaster.
Those are some solid takeaways for sure.
And they also had some words of caution.
Right? Oh, yeah, they definitely did.
They said ignoring communications from your co-owners is a big no-no.
It's a recipe for disaster.
Why is that?
Well, ignoring communication just escalates the conflict and makes finding common ground even harder.
It's like shutting down any chance of resolving things peacefully.
Exactly. And it can also be seen as bad faith by the court, which can hurt your case in the long run.
So keep those lines of communication open.
Absolutely, even if it's difficult.
And they also warned against underestimating the costs involved.
Oh, yeah, the cost can add up quickly.
Like what kind of costs are we talking about?
Well, legal fees, of course, but also property valuations, expert witness fees, court costs, all sorts of things.
It's not just a small filing fee and you're done.
Nope, it can get expensive.
So going into this with your eyes wide open is crucial.
Couldn't agree more. You need to understand the potential financial burden before you make any decisions.
Makes sense. And I think what's really interesting is how the Martinez Law Center emphasizes the emotional side of these disputes.
It's a big part of it, for sure.
It's not just a business transaction. It's families, relationships, shared histories, all tangled up in this legal mess.
Absolutely. And those personal dynamics can make things even more complicated and challenging.
They definitely can. Speaking of real-life examples, let's go back to that Orange County beachfront property dispute.
The one with the siblings.
That's the one that ended in a partition by sale.
So they sold the property and split the proceeds.
Exactly. But it wasn't just a simple division. They had to take into account one sibling's contributions to the property's upkeep.
Oh, interesting. So it wasn't just a straight split based on ownership percentages.
Right. They had to adjust the division to reflect the fact that one sibling had invested more in maintaining the property.
It's all about fairness in the end.
And remember that Riverside investment property?
The one where one investor bought out the others.
That's the one that was a classic partition by appraisal scenario.
Yep. A court-appointed appraiser determined the fair market value, and then one investor paid the others their share.
Exactly. And that avoided a potentially messy sale on the open market.
It's a good option when it's feasible.
And then there's the San Diego County family farm.
Where they actually divided the land.
That's right. They went with partition in kind.
So different branches of the family each got a portion of the land.
Exactly. They were able to keep the farm within the family, but just divide it up.
That's a great outcome, especially for a multi-generational family farm.
It preserves the legacy.
It does, and it allows different branches of the family to continue farming if they choose to.
And we can't forget about the commercial building in Los Angeles.
Oh yeah, what happened there?
The former business partners were able to negotiate a settlement during the partition action.
So they avoided a forced sale.
They did.
Yeah.
And that allowed them to salvage, at least to some degree, their business relationship.
It's always better to find a solution that works for everyone, if possible.
I agree. These cases really highlight how different the outcomes of partition actions can be.
It's definitely not one size fits all.
But there's one thing that really stands out to me: the importance of a well-crafted partition agreement.
Yeah, that can make a huge difference.
It's like a prenup for co-ownership, wouldn't you say?
Exactly. It's a proactive way to manage potential conflicts and avoid ending up in court.
So if you're thinking about co-owning property with someone, this is something you should definitely consider.
Couldn't agree more. It's all about planning for the future and avoiding potential headaches down the road.
So we've covered a lot of ground here. Just to recap for our listeners. Partition actions offer a legal solution when co-owners can't agree on what to do with the property.
Right.
Recent California laws aim to make the process fairer and more efficient.
And more protective.
And professional legal guidance is crucial.
Absolutely don't try to navigate this on your own.
But there's one last thing I want to leave you with.
What's that?
Even with a legally fair outcome, there can be non-financial consequences.
Oh yeah, for sure.
Like strained relationships or the loss of a family legacy.
Those are big ones.
So it's not just about the money, it's about the human side of these disputes too.
Couldn't agree more.
It's something to think about as we delve deeper into this topic in our next segment.
Definitely looking forward to it.
Me too. Stay tuned.
So we've talked about the different types of partition actions and some real-world examples, but let's dive into some of the legal specifics.
Yeah, let's get into the nitty-gritty.
All right, so the California Code of Civil Procedure, that's where all the rules of the game are laid out.
Okay, the rule book.
Exactly. It outlines the steps involved in filing a complaint, serving notice, all that legal stuff.
Sounds pretty dry.
It can be, but it's the foundation of the legal process. It's what makes sure everything is done by the book.
So it protects everyone's rights.
Precisely. And it gives the courts the power to actually enforce these decisions about dividing or selling the property.
So it's not just a suggestion, it's the law.
Exactly. The California Code of Civil Procedure makes it all official.
Okay, so we've got this legal framework, but what about the practical steps involved? What actually happens when you decide to pursue a partition action?
Well, it can seem a bit daunting, but it's actually a pretty straightforward process.
Okay, break it down for us.
First things first, you need to consult with an attorney, someone who specializes in partition actions.
Okay, so find an expert.
Exactly. They'll assess your specific situation, explain your options, and guide you through the whole process.
Sounds like a good first step. What's next?
Next comes the official part. You file a complaint with the court in the county where the property is located.
Okay, so you're officially kicking off the legal process.
You got it. And then it's all about making sure all the co-owners are officially informed.
So everyone knows what's going on.
Right. That's called serving notice, and it's a crucial part of the process.
Makes sense. So you file a complaint, serve notice, and then what?
Then it's all about case management, court hearings, and ultimately reaching a resolution.
So there's a whole legal dance that takes place?
Yeah, there is, and it can take some time, but having that attorney by your side can make a huge difference.
So they're like your legal choreographer guiding you through all the steps.
Exactly. They make sure you don't trip up along the way.
And speaking of tripping up, The Martinez Law Center highlighted some common pitfalls to avoid.
Oh, yeah, they've seen it all.
What are some things to watch out for?
Well, one big one is failing to consider all your options. Sometimes people get so focused on one solution that they overlook other possibilities that might be better for everyone involved.
Okay, so don't be too quick to jump to conclusions.
Right. Explore all your options. Talk to your attorney. See what makes the most sense for your specific situation.
Makes sense. What else?
Another common mistake is underestimating the potential costs.
Right, we talked about that earlier.
Legal fees, expert witness fees, property valuations, it all adds up, and it's important to be prepared for that financial burden.
So don't go into this thinking it's going to be cheap.
Definitely not. And perhaps most importantly, they emphasize the importance of not going it alone.
Don't try to be your own lawyer.
Exactly. These cases are complex, and the law can be tricky. Having an experienced attorney on your side can make all the difference.
It's like having a guide in a foreign country you wouldn't want to wander around aimlessly.
Exactly. You need someone who knows the lay of the land and can help you navigate the complexities.
Okay, so we've got the steps involved, the pitfalls to avoid, but what about the money? Let's talk about the costs associated with partition actions.
Right, let's break it down.
First up, we've got legal fees. That's a given, right?
Yeah. Those are unavoidable, but they can vary depending on the complexity of the case and the attorney's experience.
So you get what you pay for.
Pretty much. And legal fees can be billed hourly or as a contingency fee.
What's a contingency fee?
It means the attorney only gets paid if you win the case. And they typically take a percentage of the settlement or award.
Okay, so it's a risk-reward situation for the attorney.
Exactly. They're taking on the risk of not getting paid if you lose, but they get a bigger reward if you win.
Makes sense. What other costs should people be aware of?
Well, besides attorney fees, there are court costs, filing fees, service of process fees, all those administrative expenses.
So those are just the costs of doing business with the court?
Yeah, pretty much. And then there are expert witness fees.
Expert witness fees.
Yep. This is where things can get pricey, especially for property appraisals.
Right, because you need someone to determine the fair market value of the property.
Exactly. And if there are any other specialized issues that require expert testimony, those fees can add up quickly.
So it's not just about the lawyer, it's about the whole team of experts you might need to bring in.
Exactly. And all of those costs need to be factored in when you're deciding whether or not to pursue a partition action.
Okay, so for someone facing a partition action, how can they keep those expenses under control? Any tips from the experts?
The Martinez Law Center recommends exploring early settlement attempts.
So try to resolve things before it goes to court.
Exactly. Resolving things early can save a lot of money in legal fees and other expenses.
And it can also save a lot of stress and heartache.
Absolutely. And another tip is to keep the lines of communication open with your attorney.
So don't be afraid to ask questions or voice your concerns.
Definitely keeping your attorney in the loop can prevent unnecessary work and expenses.
Makes sense. What else?
In some cases, co-owners can agree to split costs fairly through cost-sharing agreements.
So everyone chips in.
Exactly. It's all about collaboration and being proactive.
It makes sense to try to work together to minimize the financial burden.
Absolutely. And it can also help preserve relationships, which is always a good thing.
Now let's talk about a type of partition action that often carries a lot of emotional weight, those involving inherited property.
Oh, yeah. Those can be tough.
It seems like those would be particularly challenging to navigate, given the family dynamics and the sentimental value often attached to inherited properties.
You're absolutely right. These cases can be very emotionally charged.
And the Martinez Law Center has a lot of experience handling these sensitive cases, right?
They do, and they emphasize the importance of acknowledging those emotional ties to the property.
So you're saying don't just treat it like a business transaction.
Exactly. These properties often hold sentimental value for the families involved, and it's important to be sensitive to that.
Makes sense, but at the same time, you also need to be realistic about the financial considerations, right?
Absolutely. You can't let emotions cloud your judgment when it comes to making important financial decisions.
This is the delicate balance.
It is, and that's where having an experienced attorney can be invaluable. They can help you navigate those emotional complexities and make sure you're making decisions that are in your best interests, both financially and emotionally.
Okay, so for someone facing a partition action involving inherited property, how can they handle those tricky family dynamics? Any advice from the experts?
The Martinez Law Center encourages open and honest communication with family members.
So talk it out.
Exactly. Try to understand everyone's goals and concerns and see if you can find some common ground.
And if communication breaks down or things get too heated,
They recommend exploring mediation.
Bringing in a neutral third party to help facilitate those conversations.
Right. Mediation can be a great way to de-escalate the situation and find a solution that works for everyone.
It's worth considering for sure, especially when family relationships are at stake.
Absolutely. And if a buyout is a possibility, they can help negotiate a fair and agreeable arrangement.
So one family member could buy out the others and keep the property.
Exactly. It's all about finding a solution that works for everyone, both legally and emotionally.
It's fascinating how the law has to grapple with those intangible, emotional aspects of property ownership.
It does, and it makes these cases much more complex than just simple financial transactions.
It's about people's lives, their histories, their memories, all tied up in these legal battles.
Exactly, and that's why having compassionate and understanding legal representation is so important.
Speaking of numbers, let's talk about real estate appraisals.
The backbone of many partition actions.
Right. They're crucial for determining the fair market value of the property.
Which is essential for an equitable division or sale.
So how do these appraisals work in the real world? What factors do appraisers consider when determining a property's value?
Appraisers take a comprehensive approach. They look at everything.
Like what?
Well, they consider the property's location, of course, condition, size, age, any recent renovations or upgrades.
Okay, so the physical characteristics of the property.
Right. And they also look at current market trends, recent comparable sales in the area, all those factors that influence what buyers are willing to pay.
So it's a pretty involved process.
It is. Appraisers are essentially real estate detectives gathering all the evidence to determine a property's true worth.
And that valuation plays a key role in partition actions, right?
Absolutely. It sets the stage for buyouts, sales divisions. It's the foundation for ensuring everyone gets their fair share.
Let's focus on partition by sale for a moment. How do appraisals fit into this specific type of partition action?
Well, in cases where physically dividing the property just isn't feasible, like with a single-family home or a commercial building, a partition by sale becomes the go-to option.
So you sell the property and divide the proceeds.
Exactly. And the appraisal is crucial for determining the listing price and ensuring a fair distribution of the proceeds.
Okay, so it sets the bar for the entire sale process.
Pretty much, yeah. It's the benchmark against which all offers are measured.
Makes sense. And it also protects the co-owners from getting lowballed, right?
Absolutely. Having that independent appraisal helps ensure that everyone receives a fair price for their share of the property.
It sounds like appraisals act as a crucial safeguard throughout the entire process.
They do, and they become even more important when dealing with inherited property, where those emotional attachments can sometimes cloud judgments about a property's true value.
Right, because sentimentality can inflate the perceived value in someone's mind.
Exactly. Having that objective appraisal helps bring everyone back down to earth and ensures a fair outcome based on market realities.
Now let's turn our attention to a specific group of individuals who often face unique challenges in partition actions. California business owners. How do partition actions play out when business partnerships go sour or business real estate is jointly owned? It seems like there would be a lot of extra layers to consider.
You're right. Business-related partition actions can be particularly complex. They often involve higher stakes, more intricate financial arrangements, and the potential for significant disruption to business operations.
So it's not just about dividing the property, it's about disentangling a whole business partnership.
Exactly. And that's where having an attorney who understands both business law and real estate law is crucial.
Makes sense. You need someone who can see the big picture and navigate all the complexities.
Absolutely. And the Martinez Law Center has a lot of experience representing business owners in these situations.
So they're familiar with the challenges and know how to protect their clients' interests.
Do they understand the importance of minimizing disruption to the business, finding solutions that allow the business to continue operating, and ensuring a fair and equitable outcome for all parties involved?
It sounds like they're taking a very strategic and holistic approach to these cases.
They are. They're not just focused on winning the legal battle. They're focused on helping their clients achieve their business goals.
So if a business partnership hits a wall and the partners can't agree on what to do with the property, a partition action could be the key to unlocking the situation.
It could be. It's a way to untangle those ownership interests and allow the former partners to move on, whether they decide to divide the property, sell it, or have one partner buy out the others.
Okay, so let's imagine a scenario, a partition of partnership property. How does that process actually unfold? What are the key steps?
Well, it generally follows a similar path to other partition actions, but with the added complexity of business interests and legal entities.
Okay, so you've got the same basic steps, filing a complaint, serving notice court hearings, but with a business twist.
Exactly. And the specific details will vary depending on the partnership agreement, the type of business, and the nature of the dispute.
So it's even more crucial to have expert legal guidance in these situations.
Absolutely. An attorney who specializes in both business law and real estate law can be invaluable. They can help you navigate the complexities, protect your interests, and ultimately find a solution that works for your business.
It sounds like the Martinez Law Center would be a great resource for business owners facing these challenges.
They have the experience and knowledge and the client-focused approach to help business owners navigate these difficult situations and achieve the best possible outcome.
Well, that's reassuring to know, because these business-related partition actions sound pretty intimidating.
They can be, but with the right legal representation, you can approach these challenges with confidence, knowing that your interests are protected.
Okay, so we've covered the legal framework, the different types of partition actions, the costs involve the emotional complexities, and the unique challenges of business-related cases. But there's one more crucial aspect we need to address: the role of the California Code of Civil Procedure.
Ah, yes, the legal backbone of the entire process.
Exactly. It's like the Constitution for partition actions, isn't it?
You could say that it lays out the rules of the game, the procedures, the requirements. It's what ensures that everything is done by the book.
And it gives the courts the authority to make those crucial decisions about property division or sale.
Precisely. It's all about ensuring a fair and legal process for everyone involved.
So understanding the ins and outs of this code can be a significant advantage for anyone involved in a partition action.
Absolutely. It's like having the cheat sheet for the legal exam.
Okay, so we've got the legal framework, but what about the practical steps involved? It sounds like a lot to wrap your head around.
It can be, but the Martinez Law Center breaks it down nicely in their guides. They've got a really user-friendly approach to explaining these legal concepts.
Okay, so they've got our backs.
They do. They make it all much less intimidating.
So walk us through it. What are the steps?
Well, first things first, you need to consult with an attorney to understand your specific situation and potential outcomes.
Okay, so find an expert who can assess the lay of the land.
Exactly. Then comes the official part, filing a complaint with the court in the county where the property is located.
Okay, so that's where the paperwork begins.
The complaint outlines the details, the property, the co-owners, the type of partition you're seeking. It's the official document that sets the wheels in motion.
And then you have to make sure all the other co-owners are aware of the action, right?
Right. That's called serving notice. And it ensures that everyone involved has a chance to respond and protect their interests.
So it's not just a one-sided thing. Everyone gets a seat at the table.
Exactly. Fairness is paramount. And then, of course, there's case management, court hearings, discovery, all the legal procedures that lead up to the final resolution.
Wow, it sounds like a lot of hoops to jump through.
It can be, but having a knowledgeable attorney can make all the difference. They'll handle all the legal maneuvering, keep you informed, and fight for your interests every step of the way.
So they're like your legal Sherpa guiding you through the treacherous terrain.
Exactly. They make the journey much smoother and less stressful.
In the Martinez Law Center, they really stress the importance of having that experienced guide, don't they?
They do. They've seen firsthand how much easier and less stressful the process can be when you have a skilled attorney on your side.
And they also highlight some common pitfalls to avoid.
Right. They do. They want their clients to be as prepared as possible and avoid unnecessary mistakes.
Okay, so give us the lowdown. What are some of the common pitfalls?
Well, one is failing to consider all your options. Sometimes people get so fixated on one solution that they overlook other possibilities that might be more beneficial.
Okay, so keep an open mind.
Exactly. Explore all your options, talk to your attorney, and see what makes the most sense for your specific situation.
Makes sense. What else?
Another common pitfall is underestimating the potential costs.
Right, we talked about that earlier.
Legal fees, expert witness fees, property valuations, it all adds up. And it's important to go into this with a realistic understanding of the financial commitment.
So don't let those costs sneak up on you.
Definitely not. And perhaps most importantly, they emphasize the importance of not going it alone.
Don't try to be your own lawyer.
Exactly. The intricacies of partition law often require the expertise of a seasoned professional, someone who knows the ins and outs of the process and can advocate for your interests effectively.
So it's worth the investment to have that expert guidance.
Absolutely. It can save you time, money, and stress in the long run.
Okay, so we've got the legal framework, the steps involved, the pitfalls to avoid. But what about the money? Let's dive a little deeper into the costs associated with partition actions.
All right, let's break down the financial landscape.
First things first, we've got legal fees. That's a given, right?
Yeah, those are unavoidable, but they can vary widely depending on the complexity of the case, the attorney's experience, and the billing structure.
So it's important to shop around and find an attorney who fits your budget.
Exactly. And don't be afraid to ask about different fee arrangements like hourly rates, flat fees, or contingency fees.
Okay, so there are options.
There are, and it's important to find an arrangement that works for you.
Besides legal fees, what other expenses are lurking out there?
Well, you've got court costs, of course, filing fees, service of process fees, all those administrative expenses that come with navigating the legal system.
So those are just the costs of doing business with the court.
Yeah, pretty much. And then there are expert witness fees, which can add up quickly, especially for property appraisals or if you need specialized testimony from other experts.
Right, because those experts don't come cheap.
They don't, and their fees need to be factored into your overall budget.
So for someone facing a partition action, how can they keep those expenses under control? Any tips from the pros?
The Martinez Law Center recommends exploring early settlement options.
So try to resolve things before it escalates into a full-blown court battle.
Exactly. Resolving things early can save you a lot of money in legal fees and other expenses.
And it can also save you a lot of time and stress.
Absolutely. And it might even help preserve relationships, which is always a plus.
So it's a win-win.
It can be. And another tip is to communicate openly and honestly with your attorney. Keep them informed of any developments or concerns you have.
So don't be afraid to ask questions.
Definitely communication is key. The more your attorney knows about your situation, the better they can represent you, and the more likely you are to achieve a favorable outcome.
Makes sense, and it can also help prevent misunderstandings and unnecessary work, which can save you money in the long run.
Exactly. And finally, in some cases, co-owners can agree to share costs fairly through cost-sharing agreements.
So everyone contributes their fair share.
Right. It's a way to spread the financial burden and ensure that everyone is invested in finding a solution.
It's a collaborative approach that can make the process less stressful for everyone involved.
Absolutely. And it can also foster a sense of teamwork and shared responsibility, which can be beneficial in these often contentious situations.
Now let's talk about a type of partition action that often carries a lot of emotional baggage, those involving inherited property.
Oh, yeah. This can be tricky.
It seems like those would be particularly challenging to navigate, given the family dynamics and the sentimental value often attached to inherited properties.
You're right. Inherited property disputes often involve a lot more than just the property itself.
It's about family history, memories, emotional ties.
Exactly. And those factors can make these cases much more complex and emotionally charged.
And the Martinez Law Center, they have a lot of experience dealing with these sensitive cases, right?
They do, and they emphasize the importance of acknowledging those emotional ties to the property.
So don't just treat it like a business transaction.
Right. Recognize that there's a lot more at stake than just the money.
But at the same time, you also need to be pragmatic about the financial consideration.
Absolutely. You can't let emotions completely cloud your judgment when making important decisions about your future.
So it's a delicate balance.
It is.
Yeah.
And that's where having an experienced attorney can be invaluable. They can help you navigate those emotional complexities and ensure you're making decisions that are in your best interests, both financially and emotionally.
Okay, so for someone facing a partition action involving inherited property, how can they handle those tricky family dynamics? Any advice from the experts?
The Martinez Law Center encourages open and honest communication with family members.
So talk it out.
Exactly. It might sound cliche, but communication is often the key to resolving these disputes amicably.
And if communication breaks down?
They recommend exploring mediation.
So bringing in a neutral third party to help facilitate those conversations.
Right. A mediator can help family members express their concerns, understand each other's perspectives, and hopefully find a solution that preserves those important family relationships.
It's worth considering for sure, especially when you want to avoid a lengthy and potentially damaging court battle.
Absolutely. And if a buyout is a possibility, the Martinez Law Center can help negotiate a fair and agreeable arrangement.
So one family member could buy out the others and keep the property within the family.
Exactly. It's a way to honor those emotional ties to the property while still achieving a fair resolution.
It's fascinating how the law has to grapple with those intangible emotional aspects of property ownership.
It does, and it makes these cases much more complex than just simple financial transactions.
It's about people's lives, their histories, their memories, all intertwined with these legal battles.
Exactly, and that's why having compassionate and understanding legal representation is so important.
Now let's talk about a crucial part of many partition actions, real estate appraisals.
Ah, yes, the art and science of determining a property's true worth.
They're essential for setting a fair price, whether you're dividing the property, selling it, or having one co-owner buy out the others.
Exactly. Appraisals provide that objective baseline that everyone can agree on.
So how do these appraisals actually work in the real world? What factors do appraisers consider when determining a property's value?
Well, appraisers are essentially real estate detectives. They gather all the evidence they can to determine a property's fair market value.
Okay, so what kind of evidence are we talking about?
They look at the property itself, of course, location, condition, size, age, any recent renovations or upgrades.
So the physical characteristics of the property.
Right, and they also look at the surrounding market, recent comparable sales, current trends, anything that might influence what a buyer would be willing to pay.
So it's a pretty thorough process.
It is. Appraisers leave no stone unturned in their quest to determine a property's true value.
And those appraisals play a crucial role in partition actions, right?
They do. They're often the deciding factor in determining how much each co-owner receives,
Right.
whether it's through a sale, a division, or a buyout.
Let's focus on partition by sale for a moment. How do appraisals fit into that specific type of partition action?
Well, in cases where physically dividing the property isn't feasible, like with a single-family home or a commercial building, a partition by sale becomes the most logical option.
So you sell the property on the open market and split the proceeds.
Exactly. And the appraisal is crucial for determining the listing price and ensuring that the property is marketed appropriately.
Okay, so it sets the stage for the entire sale process.
It does. It's the foundation on which all offers are based.
And it protects the co-owners from getting lowballed, right?
Absolutely. The appraisal provides that objective benchmark that ensures everyone receives a fair price for their share of the property.
It's like having a neutral third party vouching for the property's value.
Exactly. It takes the guesswork out of the equation and brings a level of objectivity to the process.
It sounds like appraisals are crucial safeguards throughout the entire partition action process.
They are, and they become even more important when dealing with inherited property, where emotions can run high and cloud judgments about a property's true worth.
Right, because sentimentality can sometimes inflate the perceived value of a property.
Exactly. And having that objective appraisal helps bring everyone back down to earth and ensures a fair outcome based on market realities.
Now let's shift gears and focus on a specific group of individuals who often face unique challenges in partition actions. California business owners. How do partition actions play out when business partnerships go sour or business real estate is jointly owned? It seems like there would be a lot of extra layers to consider compared to typical property disputes.
You're absolutely right. Partition actions involving businesses can be much more complex than those involving individuals or families.
So what makes them so different?
Well, for one thing, the stakes are often much higher.
We're talking about businesses, livelihoods, potentially large sums of money.
Exactly. And the legal and financial arrangements are often much more intricate.
You've got partnership agreements, operating agreements, all sorts of legal documents that need to be considered.
Right. And there's also the potential for significant disruption to business operations.
So it's not just about dividing the property. It's about finding a solution that minimizes the impact on the business itself.
Exactly. And that's where having an attorney who understands both business law and real estate law is crucial.
Makes sense. You need someone who can see the big picture and navigate all the complexities.
Absolutely. And the Martinez Law Center has a lot of experience representing business owners in these situations.
So they're familiar with the challenges and know how to protect their clients' interests.
Do they understand the importance of finding solutions that allow the business to continue operating, minimize financial losses, and preserve valuable business relationships?
So if a business partnership hits a wall and the partners can't agree on what to do with the property, a partition action could be the key to unlocking the situation.
It could be. It's a way to legally separate those ownership interests and allow the former partners to move on, whether they decide to divide the property, sell it, or have one partner buy out the others.
It's like a legal divorce for business partners.
Exactly. And just like in a divorce, it's important to have an experienced attorney on your side to guide you through the process and protect your interests.
Okay, so let's imagine a scenario, a partition of partnership property. How does that process actually unfold? What are the key steps?
Well, it generally follows a similar path to other partition actions, but with the added layer of complexity that comes with business entities and legal agreements.
Okay, so you've got the same basic steps, filing a complaint, serving notice, discovery court hearings, but with a business twist.
Right, and the specific details will vary depending on the partnership agreement, the type of business involved, and the nature of the dispute.
So it's even more crucial to have expert legal guidance in these situations.
Absolutely. An attorney who specializes in both business law and real estate law can be invaluable. They can help you navigate the complexities, protect your interests, and ultimately find a solution that works for your business.
It sounds like the Martinez Law Center would be a great resource for business owners facing these challenges.
They would be. They have the experience, the knowledge, and the client-focused approach to help business owners navigate these complex situations and achieve a fair and equitable outcome.
Okay, we've talked about the legal framework, the steps involved, the pitfalls to avoid, and the unique challenges of business-related cases. But let's shift gears for a moment and talk about the California Code of Civil Procedure.
Yes, the legal foundation of it all.
Exactly. It's the comprehensive set of laws that outlines the entire partition process.
From start to finish, it's the rule book for how these cases proceed.
It sounds like pretty dense reading.
It can be, but it's essential for understanding the legal intricacies of partition actions.
And it's what gives the courts the authority to make those binding decisions about property division or sale.
Right, it's the legal framework that ensures a fair and orderly process.
So understanding the California Code of Civil Procedure can be a significant advantage for anyone involved in a partition action.
Absolutely. It's like having the inside scoop on how the game is played.
Okay, so we've got this legal foundation, but how does it translate into practical steps? What actually happens when you file a partition action?
The Martinez Law Center has a great way of breaking it down into manageable steps.
Okay, walk us through it.
First and foremost, you need to consult with an attorney who specializes in partition actions.
Okay, so find an expert who can guide you through the maze.
Exactly. They'll assess your specific situation, explain your options, and develop a strategy for your case.
So they're your legal Sherpa guiding you through the treacherous legal terrain.
Exactly. They make the journey much smoother and less stressful.
Okay, so you've got your attorney. What's next?
Next comes the official part, filing a formal complaint with the court.
So that's where the paperwork begins.
It is. The complaint outlines all the details, the property, the co-owners, the reasons for the action. It's the official document that kicks off the legal process.
And then you have to make sure all the other co-owners are aware of the action, right?
Right, that's called serving notice. And it's a crucial step in ensuring that everyone involved has a chance to respond and protect their interests.
So it's all about fairness and transparency.
Exactly. Everyone gets a seat at the table. And then the case moves forward with court hearings, potential mediation attempts, and possibly even a property appraisal to determine its fair market value.
It sounds like a lot of back and forth, a lot of steps involved.
It can be, but having a knowledgeable attorney by your side makes all the difference. They'll handle all the legal maneuvering, keep you informed, and advocate for your best interests every step of the way.
So you don't have to navigate this alone.
Exactly. You've got an expert in your corner guiding you through the process.
And the Martinez Law Center, they really stress the importance of having that expert guide, don't they?
Yeah, they do. They've seen firsthand how much smoother and less stressful the process can be when you have an experienced attorney by your side.
And they also highlight some common pitfalls to avoid, right?
They do. They want their clients to be as prepared as possible and avoid unnecessary mistakes.
So give us the rundown. What are some of those common pitfalls?
Well, one is failing to consider all your options. Sometimes people get so focused on one particular solution that they overlook other possibilities that might be more beneficial.
Okay, so don't be too quick to jump to conclusions.
Right. Explore all your options, talk to your attorney, and see what makes the most sense for your specific situation.
Makes sense. What else?
Another common pitfall is underestimating the potential costs involved.
Right, we talked about those earlier.
Legal fees, expert witness fees, property valuations, it all adds up. And it's important to go into this with a realistic understanding of the financial commitment.
So don't let those costs sneak up on you.
Definitely not. And perhaps most importantly, they emphasize the importance of not going it alone.
Don't try to be your own lawyer.
Exactly. Partition actions can be complex, and the law can be tricky. Having an experienced attorney on your side can make all the difference in the outcome of your case.
So it's worth the investment.
Absolutely. It can save you time, money, and stress in the long run.
Okay, so we've covered the legal framework, the steps involved, the pitfalls to avoid. But let's get down to brass tacks. What about the money? Let's talk about those costs associated with partition actions.
All right, let's break down the financial landscape.
So first up, we've got legal fees. That's a given, right?
Yeah, those are unavoidable, but they can vary depending on the complexity of the case, the attorney's experience, and the billing arrangement.
Okay, so shop around, find an attorney who fits your budget, and don't be afraid to ask about different fee structures.
Exactly. There are options, and it's important to find an arrangement that works for you.
Besides legal fees, What other expenses are lurking out there?
Well, there are court costs, of course, filing fees, service of process fees, all those administrative expenses that come with navigating the legal system.
So those are just the costs of doing business with the court.
Yeah, pretty much. And then you've got expert witness fees.
Expert witness fees.
These can be significant, especially for property appraisals.
Right, because you need an expert to determine the fair market value of the property.
Exactly. And if there are other specialized issues that require expert testimony, those fees can add up quickly.
So it's not just about the lawyer's fees, it's about the whole team of experts you might need to bring in.
Right. And all those costs need to be considered when deciding whether or not to pursue a partition action.
So for someone facing a partition action, how can they keep those expenses under control? Any tips from the pros at the Martinez Law Center?
They always recommend exploring early settlement options.
So try to resolve things before it escalates into a full-blown court battle.
Exactly. Resolving things amicably can save a lot of money on legal fees and other expenses.
And it can also save a lot of stress and heartache.
Absolutely. And often it helps preserve relationships, which is a valuable bonus.
So early settlement is a win-win.
It can be, and they also emphasize the importance of keeping those lines of communication open with your attorney.
So ask questions. Don't be afraid to voice your concerns.
Exactly. The more your attorney knows about your situation and your goals, the better they can represent you. So we've talked a lot about the ins and outs of partition actions, the legal procedures, the costs, the emotional complexities, the different types of properties involved. But there's one crucial piece of advice that I want to emphasize.
Okay, I'm all ears.
Don't try to navigate this alone. Seek professional legal guidance right from the start.
So you're saying having an experienced attorney on your side can make all the difference?
Absolutely. These cases are complex, the law can be tricky, and the stakes are often high.
And we're not just talking about financial stakes, right?
No, we're also talking about relationships, family legacies, business partnerships, all those things that can get tangled up in these property disputes.
It's not just about the property itself. It's about the impact these disputes can have on people's lives.
Exactly, and that's why having an attorney who understands both the legal and the emotional aspects of these cases is crucial.
Okay, so let's talk about the Martinez Law Center. They've been a recurring theme throughout our deep dive into partition actions, and for good reason.
They're the real deal when it comes to this area of law.
So what sets them apart from other firms? What makes them the go-to experts in partition actions?
Well, for one thing, they have a proven track record of success. They've represented countless clients in partition actions throughout Southern California, and they have a deep understanding of the legal complexities involved.
Okay, so they know their stuff.
They definitely do, and they also have a client-focused approach. They prioritize clear communication, personalized attention, and a commitment to achieving the best possible outcome for each client.
So it's not just about winning the case, it's about helping their clients navigate this challenging process and come out on the other side in a good place.
Exactly. They understand that these cases can be incredibly stressful, and they're dedicated to making the experience as smooth and stress-free as possible for their clients.
It sounds like they're not just lawyers, they're also counselors and advisors.
You could say that they recognize that these cases involve a lot more than just legal issues, and they're committed to providing holistic support to their clients.
Let's break down their approach a bit further. How do they use their knowledge and experience to actually benefit their clients? What are some of their key strengths?
They're known for their thorough case analysis. They take the time to understand every detail of the case, the property, the co-ownership situation, the relevant legal precedents, and they develop a strategy that's tailored to each client's unique needs.
So it's not a one-size-fits-all approach.
Definitely not. They recognize that every case is different, and they treat each one with the individual attention it deserves.
Okay, so they're thorough, they're strategic. What else sets them apart?
They're also incredibly skilled negotiators. They've successfully resolved countless disputes before they even reach the courtroom, which saves their clients time, money, and emotional stress.
That's a valuable skill set, especially when dealing with family disputes or business partnerships, where preserving relationships is often a top priority.
Absolutely, and if litigation becomes unavoidable, they're fierce advocates in court. They're not afraid to fight for their clients' rights, and they have a proven track record of success in the courtroom.
So they're not just negotiators, they're also litigators. They're prepared to handle whatever comes their way.
Exactly. They're well-rounded and experienced in all aspects of partition actions.
Now let's talk about the elephant in the room. The costs. We know legal fees can be a major concern for anyone facing a partition action. So how does the Martinez Law Center handle this aspect?
They're very upfront and transparent about their fees, and they offer a variety of payment options to make their services accessible to everyone.
Okay, so they're not trying to hide anything. They're open and honest about the costs involved.
Exactly, and they also work closely with their clients to develop a payment plan that fits their budget.
So they're not just focused on winning the case, they're also mindful of the financial impact on their clients.
Absolutely. They believe that access to quality legal representation shouldn't be a financial burden.
Now let's talk about appraisals. We've discussed how crucial they are in partition actions. But how does the Martinez Law Center ensure that those appraisals are accurate and fair?
They have a network of trusted and experienced appraisers who specialize in various types of properties. They work closely with these appraisers to make sure the valuations are thorough, objective, and reflect the current market conditions.
So they're not just picking any random appraiser out of the phone book.
Definitely not. They're very selective about who they work with, and they make sure that the appraisers they use are highly qualified and experienced.
And they review the appraisals themselves, right?
Absolutely. They make sure that the appraisal reports are accurate, complete, and meet all legal requirements.
So they're not just taking the appraiser's word for it. They're doing their due diligence to ensure that their clients are getting a fair valuation.
Exactly. They're advocating for their clients every step of the way.
Okay, we've talked about the legal expertise, the client-focused approach, the cost management, and the importance of accurate appraisals. What other benefits come with working with the Martinez Law Center?
One of the things their clients consistently praise is their communication. They're always available to answer questions, address concerns, and provide updates on the case.
So they keep their clients informed every step of the way.
They believe that communication is key to a successful attorney-client relationship.
And they explain things in plain English, right?
Absolutely. They avoid legal jargon and make sure their clients understand everything that's happening in their case.
That's so important because legal matters can be incredibly confusing, especially for those who aren't familiar with the legal system.
It can be overwhelming, but the Martinez Law Center makes it their mission to make the process as clear and understandable as possible for their clients.
Okay, so we've got the legal expertise, the communication, the client-focused approach. What else sets them apart?
They also have a deep understanding of the emotional complexities involved in partition actions, especially those involving inherited property or business partnerships.
Right. Those cases can be incredibly emotionally charged.
They can be, and the Martinez Law Center recognizes that they approach these cases with sensitivity and compassion, and they're skilled at helping their clients navigate those difficult emotions while also protecting their legal rights.
So they're not just lawyers, they're also counselors and mediators.
You could say that they understand that these cases involve a lot more than just legal issues, and they're committed to providing holistic support to their clients.
Well, it sounds like the Martinez Law Center really goes above and beyond for their clients, whether they're individuals dealing with family disputes or business owners facing complex legal challenges.
They do. They're dedicated to providing high-quality legal representation that's both effective and compassionate.
And they're a valuable resource for anyone dealing with the complexities of partition actions in California.
Absolutely. They're the experts you want on your side.
Well, that about wraps up our deep dive into partition actions in California. I hope our listeners feel more informed and empowered to navigate these complex situations.
I agree. Knowledge is power, and understanding your rights and options is crucial when dealing with property disputes.
And remember, if you're facing a partition action or any other legal matter related to real estate, don't hesitate to reach out to the Martinez Law Center. They're the experts you can trust.
They're a fantastic resource for anyone in need of legal guidance.
That's it for today's show. We'll be back next time with another fascinating deep dive. Until then, stay curious.
Call now 714-442-9741. Thank you.